Greetings, my fellow Americans, and welcome to the Great Montana Conspiracy Podcast. Heads up, this particular issue may get emotional. I've tried to do personal stories in the past, and as a consequence, I break down emotionally and am unable to proceed. It's easy to type about things when you can walk away from them and come back. But when you have to talk about them in real time, it can get emotional. So if I do break down, and I do, please forgive. I'm going to try to maintain my composure. I've been trying to meditate, try to get myself to where I can be in a mindset where I can release try to do this in a methodical, across the board, bullet point way so I don't trip it up. But today's subject is actually on my personal experience in the first revocation attempt that was brought against me by the Montana Department of Corrections and Dave Edwards, the probation officer, which of course was just a continuation of the attempts to try to compel me to confess to a crime they knew I didn't commit in order to free themselves of liability and consequence. This was a personal request. This was a request made to me to talk about this particular issue. I had been mentioning the particular aspects of this story to my producer, and my producer thought it would be a great idea to go ahead and try this particular subject matter. But of course, the issues he wanted me to talk about have background, and they have to be put in their proper context, and therefore it encapsulates a lot of things that were just done wrong. They're offensive, they're degrading, they're humiliating. The lies are allowed to be perpetuated. It hurts me deeply, and I apologize in advance if this does break down into me becoming emotional. I'm going to try to get through this in one rushed movement. And just for the record, this is my third attempt, so let's try this again, shall we? To be clear, basic background. I sued the city of Kalispell in 2003 and was thrown into prison for that effort. I was detained for 16 months without a trial or probable cause hearing. I was arrested in a warrant that was issued at 4:33 in the morning, or 4:44 in the morning, based upon paperwork that was filed at 4:33 in the morning. No court signature, no judge signature, no court docket. The papers were not even filed in the court until 4 days after my arrest. Just a host of problems. The details are strung out in my book, the U.S. Political Prisoner since 2004, which of course is available on Amazon. Strongly encourage you to buy that if you want a full basic background of what led to this part. Again, just basic encapsulation. I ended up spending 5 full years in prison on a sentence of 20 years with 15 of those years suspended. Actual language of the order, which will become important in a few minutes. I spent the full 5 years. I was eligible for probation, actually, technically, before I even saw a trial, because a 5-year sentence in Montana, if you do 1/4 of your time, you're actually eligible for parole. I was eligible for parole, therefore, after 14 months, and I didn't see trial till 16 months. And then, because the conditions set by the sentence required me to go through what they called Phase 1, which is the informational stage of sex offender treatment, and therefore I was remanded to Montana State Prison until such time as I could complete that process. After I completed it, I went before the parole board, and the parole board required me to confess. They wanted to know specifically the issue. The question brought before me was, "Oh, Mr. Glick, we see you've done excellent behavior inside the prison. You have no disciplinary actions against you. You maintain a work ethic. You don't have any problems. Your supervisors give you glowing reports. You look like a very good candidate for parole release. So tell us, Mr. Glick, why did you do your crime?" My response was, "I didn't do a crime." He says, "Well, then why are we here?" "Because I sued Kalispell, and Kalispell trumped up a charge, had me railroad through a conviction, and sent me to prison. I'm here on that prison sentence, not because I committed a crime, but because they wanted to stop a lawsuit." "Thank you, Mr. Glick, parole denied." Literally, that was how it went. The paperwork that came back later said they required me to be eligible for parole again. I would have to participate in what they called Phase 2 of sex offender therapy. Now in Montana, Phase 2 requires an admission to the crime. Now, this flies in the face of the Fifth Amendment. Fifth Amendment clearly states that you are protected against to be compelled to make incriminating statements against yourself. And the U.S. Supreme Court has come back and actually upheld that the Fifth Amendment survives post-conviction. Legally, Montana cannot compel you to say that you did something or to compel you to confess to a crime, even if you're convicted. It's unconstitutional. Montana does it. The entire phase 2 of sex offender therapy requires to participate. Even to participate, much less graduate, you have to confess. Therefore, they wrote in the recommendation that before I could appear before the parole board again, I must attend sex offender therapy 2, i.e., I must confess. Obviously, I could not confess, therefore I could not take phase 2. Now, another interesting point is that my specific sentencing conditions only required me to complete phase 1 and only proceed to phase 2 if my treatment provider recommended it. My treatment provider in prison was Sam Griffel. He did not make any such recommendation. In fact, he told me specifically, Ron, you cannot complete phase 2, therefore I'm not recommending it. He did not. The only condition under which I could have been compelled to continue into this admission phase of treatment, so-called treatment, was to confess. I have never confessed to a crime I don't want to commit. I'm never going to confess to a crime I didn't commit. If I committed it, that's a different story, but I didn't commit a crime. And to compel me to try to force me into a situation and make me serve additional time, an issue in entirely of itself. And again, I'm getting way laid off track here because in providing this brief history does create a foundation for what happened next. So I served my full 5 years. The parole board was not able to compel me to confess. They released me probation. Another aspect, my sentencing conditions, remember I said this would be important in a few minutes. My sentencing conditions said that I was committed to 20 years Montana State Prison with 15 of those years suspended. It's important. A suspended sentence, by definition, is a sentence that is not served. You are released free and clear into the community. The only way you get those 15 years back is if you commit another crime. That's the definition of a suspended sentence. A suspended sentence that is not served at the time it is imposed. Not served. A probationary sentence is a supervisory sentence, a sentence by which you are under supervision and custody of the state that you are detained under, in this case, Montana. Prior to my release from prison, I was told I must sign papers agreeing to terms of probation. I argued and said, no, my sentence does not require me to do probation. I have a suspended sentence. After these 5 years, I should be free. The response from the Department of Corrections was that if I refused to sign the papers, I would not be released. I would be continued to be held in custody indefinitely until I agreed to sign those papers. The exact language was, I would be signed out of my 5-year commitment and then immediately rearrested and detained until such time as I either agreed or I was held in violation of those terms of my release and put back into prison for 15 years. So under threat of duress, I had to sign those papers or I would not have been released because I realized, keep in mind, at this point in time, my appeal was still pending. It was absolutely, I had no idea the appeal, but I knew I could not do, after 5 years of being inside the walls and having no access virtually to any kind of real defense, real contact with witnesses, real contact with individuals who might exonerate me, I knew I had to be outside those walls to do anything. I had no advocates on the outside. The attorneys are worthless when it comes to trying to advocate for you beyond what they're required to do by law. They're not real advocates. The appellate defenders, the public defenders, none of them are your advocates. They're required to file certain papers to represent you in court. They are not your advocate to try to prove your innocence. And if you think they are, you're wrong. Because definitely not in Montana, they're not. They do the bare minimum they're required to do. Let me apologize for that interruption. I'm sure you guys heard the door knock in the background. That's something I had to answer under the terms of my probationary release. If I have a probation officer show up at my door and I do not answer the door, I can go to jail for avoiding contact. So it was one of those things I had to interrupt the podcast for. So, therefore, forgive. We'll start back again. And once again, I was talking about the appellate defenders um, and the public defenders. That they don't represent you. They don't. They're not your advocate outside. Therefore, I knew I had to get released from prison if I was going to have any chance. Now, of course, anybody who's read my blog, read my book, followed my history, made any kind of research to find out. Obviously, the voice I thought I would have out here is largely muffled. It is deflected by people in positions of authority who do their level best to try to misrepresent what I'm doing, what I'm saying, take things out of context, actually directly make up lies to say I'm doing things I'm not doing in order to get people dissuaded from actually listening to me. It's the reason why, if you're watching this on YouTube, you'll notice that possibly that I have detracting votes. These detracting votes are not people who actually listen to the podcast and don't like the content. They are people who are out here deliberately looking at the message I'm providing. They don't want people to listen to it, so they've denounced the video in order to allow for the search parameters, their algorithm that YouTube runs, to make it less available to the general public. It has nothing to do with whether they personally approve or disapprove of the content, other than the fact they don't want my message out there. So getting out and trying to speak in the community, getting out at that point in time, was really important to me. Obviously, I didn't have any other frame of reference and no way to foresee the future. So under duress and threat of being returned to prison for 15 years for refusing to sign these papers, I signed them. Now, anybody who understands contract law or understands compulsion knows that consent must be voluntary. It cannot be compelled through duress or threat. Well, my signature was compelled through duress or threat. But of course, that argument has been repeatedly ignored and overseen and overlooked and everything because it doesn't exist as far as they're concerned. There was no duress. I signed it voluntarily. They don't care, even though I've insisted to the contrary. But moving the story along, I was released from prison after I agreed to sign this under duress on February 18th, 2009. Ironically enough, and I guarantee there's no irony involved in this, this was a deliberate strategy. The appellate decision upholding my conviction was released the very next day, February 19th, 2009. And of course, the state Supreme Court didn't even address 4 of the 5 issues we raised. And it barely touched on the actual issue that they had sent us back to re-argue. It was an upheld conviction. There was no reason to defend it, but they ignored the aspects that were critical and upheld the conviction. Consequently, I was stuck with being supervised under probation and under the probation officer, Dave Edwards. And once again, I'm being interrupted, ladies and gentlemen. I think you've met her before. Say hello to Felicia, who once again wants to get attention over here. But anyway, so the moment I met with Dave Edwards, it was an adversarial relationship. He made it very clear he didn't like the idea that I denied. He told me in his own words that he felt that without having any real understanding of the case, he felt that I was like every other denier. I was more concerned with being caught than I was with anyone's innocence or anyone's victim mentality or anything. It's just in his mind, or at least as he portrayed his mind to me. I cannot believe this is actually his actual thoughts. He felt it was his responsibility to force me to confess. And he told me repeatedly I needed to confess. I needed to admit what I had done. I needed to move on. The only way to move on with my life and to move on free of arrest, free of prison, free of anything was to confess. And he told me this multiple times over the next 2 months. Constantly, repeatedly, I needed to stop doing all the legal work. I needed to stop trying to defend against this. I needed to accept it, be responsible for it, and go on with my life as a sex offender and an admitted sex offender and whatever that entailed. He repeatedly required me to attend sex offender therapy beyond what I was required by court order. Again, I completed my sex offender counseling in prison. There was no recommendation to continue on. Once again, as the parole board had done, Dave Edwards decided that the probation office's job was to compel me to confess. Knowing that to participate in a phase 2 sex offender therapy course would require me to confess, he made it a condition. He didn't have the authority to do that, he just did. He said, "You have to do this." And I said, "I don't have to do this. My conditions are simple. Phase 1, and only proceed if on the recommendation of my sex offender counselor. I don't have a recommendation to continue, therefore I'm not required." The other aspect that was really that was one of the grounds for the revocation. The actual revocation actually had another component, and that was the work requirement. His specific requirement was that, hang on a second, I've got to get my cat. Hang on, she's actually stealing my papers. Felicia. Forgive me, ladies and gentlemen, when you have cats, they have a mind of their own. But the actual subject of the revocation was threefold, and two of them are pretty much the same issue. One was the work condition, and two of the conditions were related around alleged refusal to comply with sex offender therapy. The work condition was that supposedly I wasn't working. Now, mind you, at the time I came out was in 2009. Look back at your history of the U.S. economy at that point in time. We were in a recession. There were people on unemployment who had been on unemployment for over a year and were continuing to get extensions on unemployment at that time. The work market was collapsing. There were no jobs to be had. But I was made worse because Dave Edwards put conditions over me that made it impossible for me to get work. I didn't have a degree. My expertise were in areas of child recreations, gaming, recreational aspects, collections, all of which involved interaction with children, barred from doing so. But Dave Edwards took it a step further. He said I could not work in an environment to where there was any reasonable expectation of me having a supervisory position over children. Now, that is a condition of my release, or at least a condition of the probation conditions. However, his interpretation was that if I was working in any job dealing with the general public and a child walked in, I would at that point be in a position of supervisory control over that child, and I would be in violation of my conditions, and therefore I could not work with the general public. I could not work at a call center because a child could call in. I could not work in any place where there's an expectation a child could interact with me in any capacity. Absolutely no one in the state of Montana has that condition. No one. Not even level 3 or level 1 sex offenders or level 3 sex offenders. I was classified as level 1, the lowest you can get. And by the way, there is no such thing as a level 0. Another issue entirely to deal with on the subject of Montana's peer recommendation, their sex offender registry and all of that. But regardless, lowest of the low, level 1 sex offender. Even level 3 offenders are not required to not be able. In fact, I know I've not been forced to actually go through these therapy sessions. I actually have known level 3 offenders who work with the general public just fine. They work at Taco Bell. They work at Army Navy. They work all over the community. No such restriction. But because I refused to confess, Dave Edwards was trying to make sure that he made it impossible for me to survive on the outside. He also told me that if I ever became homeless because I could not afford to pay rent or shelter expenses, I would be violated. Again, no one else has this requirement. Look it up on any registry you want in the state of Montana. There are transient sex offenders, which means they have no homes. They're living on the street because they're homeless. I was told if I became homeless, I would be revoked. And I'm still under that condition because that's never been rescinded. That's important to note. These orders and restrictions that are given to me by each individual probation officer, regardless of whether they are written instructions or written down anywhere, I am expected to follow them, because if I do not follow them, I go to prison. So these various interpretations, because they've not been rescinded or overridden, I'm still bound by them. I still can't work in any position in the community where I might be in a position where I have contact with children, because at that point I'd be in a position of supervisory control over them. I'm still not allowed to do so many things that came from the various warped perceptions of Dave Edwards. because nobody's ever gone back and revisited them or been willing to revisit them with me. My orders are to stand on the instructions and directions of each probation officer, regardless of whether they make sense or not. I don't get to lose them because I change a probation officer. So Dave Edwards comes in with this idea that he's going to compel me through these various different threats and intimidations, that he's going to force me. He's going to force me into sex offender therapy because the phase 2 would require me to, in order to participate, I have to confess. If I don't confess, I'm in violation of his instruction. I go back to prison. He set up a work condition that made it impossible for me to get work without a degree or certification, because if I worked with the general public in any capacity, I would be in violation under his interpretation of my restrictions. So he set up those two barriers that made it impossible. Now, however, this being said, I was working with Voc Rehab, vocational rehabilitation, to actually use my writing and my publishing to try to get an advertising campaign together to promote my writing and publications as a means by which to get off disability. I actually applied for disability, and I was pending SSI at the point that I got out of prison. I actually started it before I went out of prison. I recognized that I was going to have problems initially getting employment because I've been talking to lots of people in my 5 years in prison who had come out with sex offender convictions and indicated that finding work and finding an employer willing to hire me with that particular history was going to be difficult. I could spend 6 months to a year without a job. And I had a limited physical capacity of what work I could do coming out of prison because of I did have a legitimate and genuine chronic joint pain disease. It limits what I can do. Primarily my mind is my primary work component. So I already knew I was going to be limited in what I could do, limited research. From the people in community, people who had come in and out of the prison system being sex offenders, I knew that getting employment was going to be hard. So I started the process of applying for disability before I ever even left prison. So that was already pending. I was working with vocational rehab. Dave Edwards actually told Voc Rehab at one point that I could not, because their building shared space with the Office of Public Assistance, that I could not enter their building. He actually told them this. He continuously sabotaged me throughout his supervision of me. He said that if I wanted to participate in their program, it would require someone from their office to meet me outside the office and escort me into the building and escort me out of the building. And I could not approach the building. I had to do it from somewhere far enough away that I was removed, that I would not encounter anybody entering the building. And the conditions were ridiculous. It was all an effort to sabotage. He didn't want me to succeed. He didn't want me to be able to support myself because he wanted to put me back in prison. That was his threat. That was his big stick. And if I had all these conditions and these abilities to do anything, he didn't have any power. So the revocation, and I got the revocation paperwork right in front of me. I'm going to read those conditions really fast. His first violation alleged the defendant must obtain gainful employment and remain so employed to the satisfaction of the supervising officer. Again, condition of probation. Get back to that in a minute. The second one was the defendant must enter into and successfully complete an MSOTA, Montana State, I can't remember what it stands for. It's the Sex Offender Treatment Association, I think. Certified sexual offender program administered by an approved treatment provider and or facility and follow all rules and recommendations made by the program. He'll be responsible for all costs of the program. I completed that inside the prison. So, just as a point. The defendant must continue with an approved sexual offender counseling, aftercare or otherwise, for the entirety of the supervision period at his own cost, if deemed necessary by a supervising officer and sex offender therapist. Again, Sam Griffel was my sex offender therapist. He made no such recommendation. The position and recommendation of supervising officer alone can't be done. But this is what he was violating me on. Because I couldn't get work because he made it impossible for me to get work. He was sabotaging my efforts to work with vocational rehab, and he was not allowing me to proceed with the Social Security application. He let me stay out 2 months in an economy where people were getting unemployment for 6, 8, 12 months because of a recession that was going on. So it was completely unreasonable and unexpected. The revocation was not really on the grounds of which it was preceded. It was preceded upon the fact that I had a meeting a couple of days before this. A meeting with Dave Edwards approximately on April 20th. I'm in my own mind, I remember it being 3 days before, but it's right around that time. And this is the culmination of many, many meetings. He was continuing to pressure me, threaten me, telling me I needed to confess, telling me to take responsibility for the crime, telling me. But he told me in this meeting that if I just filed one more legal action, he told me to stop filing legal actions in court, and if I filed one more legal paper, I would be returned to prison. He has absolutely no legal right to say that. He does not have the right to tell me to not pursue any legal action. He doesn't have the right to tell me I can't pursue the property that I lost as a consequence of going to prison. He can't tell me I can't appeal my conviction. He can't tell me any of this. He's telling me, across the table from me, that if I continue to file papers challenging my conviction, I'd go back to prison. And I asked him right across the table from him, I said, Dave, if you were convicted of a crime that you knew you didn't commit, that was going to hang over your head for the rest of your life, at what point would you stop fighting to prove your innocence? And his response was, at the point when I'm going back to prison, which is where you're going if you file one more paper. I'm stubborn. 2 days later, I filed a petition for writ of habeas corpus with the Montana Supreme Court challenging the detention that Dave Edwards held over me, that the Montana State Department of Justice was holding over me, that I was being imposed with a condition that was not part of my sentence, and that this probationary period was not being designed to be a rehabilitation or supervisory, but it was designed as an attempt to force me and compel me through their abuse of this process to confess to a crime I did not commit, and that I've maintained my innocence of throughout this entire process. Because on April 22nd, I filed this, on April 20th, 21st, I filed this, April 22nd, I filed this. The grounds of double jeopardy, abuse of supervision to compel confession, and my Fifth Amendment rights, as I've mentioned, upheld by the United States Supreme Court, survive post-conviction. Ironically enough, as I found out later, the Supreme Court wouldn't even file it. They rejected the filing. Of course, I wasn't out to find that out because the very next day, Dave Edwards showed up at my doorstep with 5 other people, 4 police officers and 1 other probation officer. 6 people to take me into custody. Completely unnecessary. He knew this. He was telling people I was going to be violent. He was telling people I was going to resist, that I was going to have weapons. Whatever he was telling them, he had an armed battalion of people outside my room ready to basically tackle me and throw me to the ground at instant provocation. And of course, they were Kalispell police officers who I'd already sued, who the department already had reason to hold grudges against me for. So it wasn't like these were like innocent, non-involved, people. This was the Kalispell Police Department who I had sued, who I'd gone to prison over suing. I'd gone to prison over suing these people. Here's 4 of them, armed to the teeth. Keep in mind, it was April. There was snow on the ground. I have a chronic joint pain disease. I only had socks on. I asked to put my shoes on. They refused to let me put on my shoes. I was not allowed to do or say anything. I had to walk outside in handcuffs, in socks, through melting snow with a joint disease. Willful infliction of cruel and unusual punishment, anybody? Of course, everyone ignores that because Dave Edwards had become convinced I was going to be this violent protester. Once again, lies, proliferation, abuse. And of course, the moment I go to jail, Dave Edwards is tearing my room apart. Dave Edwards is going through and searching my room, looking for anything he can use against me. Illegal. Yes, one of my conditions of release was that I must submit to warrantless searches. But the whole key there is I must submit to it. I have to give consent. If I don't give consent, I can certainly be violated for not giving consent, but I don't have to let them in the room if I don't want to. I was presently facing a revocation in jail. Nobody even told me they were going through my room. I had to hear this from other people that they were going through. They never came to me for permission. They never got my consent. They ripped through my private property, ruined a good majority of it, destroyed legal papers that I've never been able to recover. And my stuff ended up in trash bags, which the only reason why any of it was saved was because my friend Don, who's down the hall, saw what they were doing and came in and said, "That's Ron's stuff. You can't throw it out." So they dropped the trash bags and left them there, and they were basically going to take off with the trash bags full of stuff. And Don said, "No, you can't take that. That's Ron's stuff." So they dropped the bags and left. So that's how my stuff came to me after I got out of jail 6 weeks later. It was in trash bags. I mean, just forget any kind of order or structure. Papers were ripped. There were pieces of half papers there that weren't intact. I mean, it was just, there was water damage on these papers. I mean, just I don't know how they did with. I mean, they must have like knocked over drinks or something while they were cleaning the room and just left the stuff in the middle of the room and started gathering it all up into sacks, and they didn't care. Papers were stuck together. It was a mess. Trying to get anything out of it. Interestingly enough, another aspect before I continue. Actually, I probably should talk about that next because I need to keep on track. But anyway, so I read the alleged conditions I supposedly violated. Dave Edwards insisted that I wasn't looking for work. He knew I was looking for work. He knew I was working with Voc Rehab. He knew I was applying for SSI. He knew I was out trying to put in applications where I could, because I didn't know where else. I mean, literally, I was going down to the job services board every single day, looking for jobs, looking for anything. I was trying to find work on the internet. I was trying to do surveys. If anybody knows anything about surveys, that's a joke. Oh, you can earn an income from home for taking these surveys. Right. You get paid 1 or 2 cents for every survey. There's just no way you can make. I mean, I'm trying every aspect I can, submitting all these websites to him to prove that I'm out there looking for work. You know, all of this. He knew it. He lied. Big surprise. He lied. He lied about everything he could because he was trying to put me back in prison as punishment for not confessing to the crime. That's what it all boils down to. After I was arrested that day, after I was thrown in jail, he called the Voc Rehab office and told them I was no longer eligible for their services because I was denied Social Security. That was a lie. He also called Social Security and told them I was no longer eligible for services because I was going to prison. Again, a lie. Ironically enough, Dave Edwards contacting the Social Security office and telling them where I was the only reason why his attempt to arrest me didn't stop my Social Security application. If he had just left well enough alone and not tried to additionally sabotage it, because he figured if he undermined my Voc Rehab service, if he undermined my potential chance for Social Security, by the time a hearing came on the revocation, he could prove there was no income potential because Social Security was no longer pending and the Voc Rehab service was no longer available to me. He deliberately tried to sabotage them by calling the Social Security office and telling them where I was. There was a letter they had sent to me the week I was arrested that they wanted me to sign to basically be the final acceptance and verification and authentication of all the information I had submitted. And upon signing that, I was approved for SSI. I wouldn't have got it if Dave Edwards had not called them and told them where I was. Surprise, surprise. By the time we have a pending hearing or a status hearing, I now have income. The one thing that he said I didn't have and didn't have any potential chance of having, I had. Because he could not try to stop the SSI process. He actually called Social Security and told them where I was because he thought that doing so would stop my pending application. It gave them an idea of where I was. They sent a letter I had not responded to because I was in jail. And they obviously weren't forwarding my mail to me. and I had no advocate on the outside able to collect my mail. Therefore, if he had simply stopped and let the revocation proceed, I would have been revoked. I'd been back in prison for 15 years because I would not be able to bring any proof of support or anything else to the court. Because, and another thing aspect, remember, prior to my arrest, even though I was not required, I was still going around trying to find a sex offender therapist because he was threatening to revoke me, to throw me back in prison for not doing so. Every single one I spoke to, every single one would not take me because I was a denier. That's the actual term that the professionals use. I was a denier. I was someone who refused to admit to the crime of which I was convicted. And as one therapist in Whitefish put it, I would become a detriment to the rehabilitation of his actual sex offender clients if I participated in a program and denied while they had to admit. Therefore, even though I was trying to comply, two reasons. One, I couldn't afford them. I had no income at that point in time. But two, they were denying me. They were telling me that I could not participate in a program because I was a denier. I was somebody who would not confess to the crime of which I was convicted, and therefore I could not participate in their programs. So to revoke me on those conditions, even though I wasn't even a condition to revoke me under, was ridiculous. But he did it anyway because I filed another legal action. I filed for a petition or writ of habeas corpus naming the probation office, naming the Montana Department of Corrections. And that's what they sent me to prison for. Or that's what they sent me back to jail for, for 6 weeks. In order to get released after those 6 years, I had to agree to participate in or find a provider. At this point in time, I had money. Not a lot. Social Security is not a lot of money to live on. But I now had money to pay for services. And I could restart looking for a sex offender therapist. But it was a requirement that in order to get released, I agreed I would participate in sex offender therapy. Dave Edwards, of course, expected that I would have run into the exact same obstacle I ran into before that he knew about. That no provider locally would give me service. First of all, I wouldn't be able to afford it on Social Security income. And second, I wouldn't be able to find anybody who would accept me because I was a denier because they'd already rejected me. Ironically enough, the one person who had not returned any of my phone calls before I was arrested, Jeffrey Scoggins, was willing to work with my financial situation and willing to accept me as a denier. Now, I don't know how or what complicity that actually has because, quite frankly, it's ironic that the one provider who could have provided me the services to avoid the revocation attempt wasn't available until after I received income. I have every reason to believe it was a financial issue because when I called Scoggins on his message, I'm like, I've been telling him the same thing I was telling everybody. I am not ordered to do this, but my probation officers require me to. And I don't have income right now, but I'm applying for SSI and I'm trying to get the services. And I'm sure that second condition was what was the breaking point. Jeff wants to get paid. Everybody wants to get paid for their time and services. They don't want to do this for free. And he certainly didn't want to bill me into infinity. So I'm absolutely certain the reason why he never called me back was because I couldn't pay. Once I could pay, all of a sudden Jeff Scoggins returns my phone call. And he was the one I ended up going through, completing the process, doing the required sex offender therapy for 2 years, additional years. And voila, completed the condition. Dave Edwards' efforts to foil failed. So, but nevertheless, it was a large overshadowing issue. One so much that he was so, and pardon the language, I don't like using bad language. I hope my previous videos have shown this, but he was so butthurt over not being able to revoke me that he actually came back and wanted to modify my conditions. He actually came to me and wanted me to voluntarily sign a modified terms of supervision. Of course I refused. I wasn't going to. He wanted me, the conditions that he came back on, he wanted me to actually agree to were ridiculous. He wanted me to come back and modify my conditions to say I couldn't use my victim's name. He wanted me to agree I wouldn't go to any medical facilities that could potentially also serve children. I mean, all these conditions, just rattle off these conditions he wanted me to modify and change. And I said, no, absolutely not. I'm not required to do this. You're compelling me to do something that I'm not required to by a court order. And you can't modify my conditions. And I actually have a case law. I should have brought that up for this particular video. There's actually a case law, and it's State versus Fields. I just don't have the actual citation numbers. It's either State versus Fields or it's State versus Hatfield. I'm pretty sure it's State versus Fields. But it says that the judicial branch cannot grant its authority to the executive branch, Department of Corrections, to modify their conditions. The Montana Supreme Court had already come back on this and said they couldn't do it. And I told Dave afterwards that you can't do this. The Montana Supreme Court said you can't do it. Well, he went back to court and filed to modify my conditions and request to amend conditions of probation supervision. Now remember, once again, I'm not supposed to be on probation. I was sentenced to 15 years suspended sentence, although there were conditions listed on my sentencing order. If I served any period of probation or parole, I was not sentenced to probation or parole. Therefore, those conditions would only apply if I fell under, at some future point, under probation or at some future point under parole. Did not. I was released directly to probation. But the actual term of the document is request to amend conditions of probation supervision. Not suspended supervision, probation supervision. He wanted to modify the conditions to read, number 29, he may not have contact with the victim in this matter. I'm going to omit even her initials, so there's no question that I'm violating any conditions here. By means of writing, telephone, third party, or in person, which I never had, nor have I since. The defendant shall not maintain any form of publication, such as a website or printed media, that uses the victim or her family by name or address. The court adopted the victim part, not the family part, by the way. But that condition was adopted almost wholesale. Modified condition, court number 23. The defendant will not have contact with any individual under the age of 18 unless accompanied by an approved, appropriately trained, responsible adult who is aware of the defendant's sexual conviction and approved by the probation and parole and sexual offender treatment provider. The defendant shall sign a no-contact contract and abide by all conditions of that contract. And by the way, no contact meant, it was ridiculous. It was like 13, 14 conditions down the line that apply to level 3 sex offenders, not to level 1 sex offenders. But regardless, it was way over the line, but the court told them I had to do it, so I had to do it. And which basically also, by the way, gave complete modification ability back to Department of Corrections, which the Montana State Supreme Court had specifically not said they cannot do. You cannot, the judiciary could not grant the Department of Corrections the ability to modify conditions after they were imposed. Cannot. The court said, in this case, absolutely, go ahead and any contract you put in front of him, it says no contact agreement, he has to sign it and do those conditions. Didn't incorporate the language of them, just simply said he must sign the contract titled no contact. They could come back at any point and modify that, require me to sign. They could say, hey, I cannot have no contact with the general public or publish podcasts or blogs or anything else, and I would have to sign it because I'm under court order to do so. Because there's absolutely no incorporation of what the actual terms are, it gives complete modification ability to the Department of Corrections. Again, forbidden by Montana's own precedent. Ignored in my case. And I have raised that issue, by the way. Ignored. The defendant shall not frequent places where children congregate. This is a really interesting one. This includes but is not limited to schools, parks, playgrounds, malls, movies, fairs, parades, swimming pools, carnivals, arcades, parties, family functions, holiday festivities, or any other place or function where children are present or reasonably expected to be present, unless accompanied by an approved and appropriately trained responsible adult who is aware of the defendant's sexual conviction and approved by the probation and parole officer and sexual offender treatment provider. defendant shall obtain permission from the officer prior to going to any of the above places. Now, it's really interesting to note the swimming pool part. At the time, I was prescribed physical therapy by my doctor for my disability. Which, interestingly enough, by the way, Edwards claimed in the original petition for revocation that I claimed a disability provided no proof. He knew I was disabled. He knew I was applying for SSI. First of all, it wasn't his place to make a decision whether I was or wasn't. I didn't have medical records. I had been in prison for 5 years. I had no medical records. I had none of my documentation. Of course I could. I went to the doctor. I got the verification from my doctor, and I brought that verification to him. I brought the order for physical therapy to him. He saw all that. He knew it existed. I didn't have my years and years and years of medical history because Mara had all those. My ex-girlfriend. And she probably destroyed them. I certainly never got them back. So to sit here and say I had not proven, I don't have to prove my disability to him. It wasn't a prerequisite. Was I applying actively for Social Security? Yes, I was. Had the application even been ruled on? No, it had not. I was actually approved. One of the rare cases where someone was actually approved. I had such a medical history, such a long-standing situation where I had such a long-standing issue of disability medical records, and I had not applied for disability because I was trying to avoid it. I was granted first round. They said the first time I applied for it, they accepted me. There was no second, there was no appeal, subsequent appeal, et cetera, et cetera, et cetera. I've known people who've got on and tried to get on disability for 2-3 years at a time. I got it within a couple of months. That's how solid my disability history was. And the only reason I hadn't gotten it sooner is because I hadn't applied for it realistically sooner. Because I didn't want to be on disability. I wanted to work. I wanted to be out there doing stuff. I didn't want to say, I'm crippled. I wanted to work. Why do you think I put out 24 books trying to build a publication empire, a company that based upon my mind and what I can do, what I can do? Because I want to work. I don't want to be on disability. I was only went on disability because I was forced into a corner where I didn't have any other choice for support. But the fact is, my medical history got me at the first go. No appeal. First go. And Dave Edwards said I wasn't disabled. Like, he's a medical expert. That was one of the things he said in his first revocation, in the initial revocation. So, all these issues, the swimming pool was because I had been going to the Summit, which is a local gym that's actually owned by the hospital. Because there's people who do physical therapy programs in there. There was a heated pool that, by the way, kids weren't supposed to be in. It's actually one of the rules of the facility. They're not supposed to be in there. But the teachers at the time, during the summer, or as the summer approached, and of course the kids were learning how to swim. In March and April, they were learning how to swim, and therefore they were getting lessons in the main pool, which was outside and away and removed by an entire physical wall from the heated pool. But as a treat, if the kids did well in their class, the teachers would bring them into the shallow area of the pool to swim in, the heated pool. I was in the deeper end. I was nowhere near them. But Dave Edwards saw an opportunity. He said, you cannot participate in your own physical therapy because there's children there. And I said, no, they're not even anywhere near. And he actually tried to accuse me of lewdly watching them from across the room. He never once tried to attend my physical therapy sessions. He had absolutely this was all speculation and made up nonsense. Just like he tried to claim that in the original revocation that I was using an adult sobriety program I had run. He alone made accusations that there were children present. There were not. He never once tried to attend one of the meetings to verify whether there were or not. He just made it up. He's working with the general public, therefore he can work with children, and therefore I'm going to say there were children present and violate him and try to allege that he's trying to violate his conditions. He's trying to find ways to work around his conditions. He makes it all up. Every step of the way he makes it up because he has no actual valid grounds to proceed on. And that's the problem. They don't have any valid grounds to proceed on, and that's where I run into the problem. But anyway, trying to get back on track, because this is going to be an incredibly long video at this point, combining the two parts that I have here. Obviously, the revocation failed. I had support, and I had, at that point in time, I was attending sex offender therapy, even though I wasn't required to. Edwards came back and modified my conditions to make it a requirement that I must attend, and he modified my conditions beyond what he made the recommendations for. I went from the court actually on its own decided to tell me that he actually declared I was on probation, where I had not previously been declared on probation. Told me I must listen to and follow any instructions and orders from my probation officer, regardless of whether they were written or not. So basically, at that point in time, they gave complete control of my supervision over the probation office to make any modifications they wanted to. The only thing that was actually done in my favor for that modification was that it went from I could not have contact with children under the age of 18 to I can have contact to female children under the age of 18. Why she did that, my attorney thinks she was just trying to find some way to make it look like she was doing the right thing. And this was Kitty Curtis back when she was on the bench. But it was so woefully wrong the other direction. My attorney at the time did not make any effort to appeal this. The orders were long in coming. Literally during this period of time, for about an 8-month period, following this modification hearing, I was under instruction to follow whatever instruction my probation officer gave, written or not, whether prescribed by the court or not. And Dave Edwards held me to the condition that I could not go any place there was a reasonable expectation children could be present. That was the condition he held me under. I could not go to the grocery store. I had to send people to the grocery store for me. At the time, I was living in the Rosebriar, which is something of almost like a flop house. It literally is like a 6x10 room. You have to go out in the hall to go to the bathroom. You have no kitchen facility. You have to go in the kitchen. I could not leave my room, ladies and gentlemen, because there were children who might reasonably be expected to be in the hall. Because although the children were not living on the premises, they were visiting people who lived there. Because people had custody issues. They had children who would come visit on visitation. They had grandchildren that come to visit. Guess what? There was a reasonable expectation children could be present outside that room. I would have to wait till after 10 o'clock at night to go take a bath, to go to the bathroom. I had more humane conditions in prison. Because David, and I asked him repeatedly, define this, dude, because you're sitting here telling me I literally cannot go anywhere. He says, well, you can go anywhere I tell you. He told me the only place I could go, basically, was to come see him to check in for once a month. That was it. It's the only place I could go. If he saw me out walking on the street, he revoked me. He literally told me if he saw me walking on the street and there was a child walking on that street anywhere, he'd revoke me. He literally told me that. So the only place I could live for 8 months was in a hole in the wall and whatever I could heat up in my room to eat. People had to go to the grocery store for me. I couldn't even go to the doctor for 8 months. I had to actually call in and get permission to go to the doctor. I had one visit in that entire 8-month period to the doctor. Now keep in mind, at this modification hearing, Dave Edwards actually justified this nonsense by saying, my attorney asked him at the hearing, he said, you're saying he cannot go to any place with a reasonable expectation a child could be present. So if Mr. Glick has a compound fracture in his leg, he cannot stand on it, he manages to crawl into an emergency room, there's a child there, you expect him to leave? And Dave Edwards says, I would expect him to remove himself from that situation. In that scenario, I have a compound fracture, cannot bear weight on my leg. I've managed to somehow make it to the ER, and I have to leave the ER under his criteria. Absolutely ridiculous. But this is what he wanted. He wanted the most inhumane conditions possible because he wanted to be able to revoke me. He figured with the most inhumane possible, it'd be a lot easier to revoke me on the most ridiculous terms. Thankfully, the court didn't adopt that when it did come down with the order. It didn't adopt them to that extreme. It did accept modifications. I do now have a censorship over my head that nobody else has. I have conditions that I literally can't conduct. I couldn't conduct physical therapy unless I got permission to do so. Thankfully, later probation officers allowed me to. But It's all a situation to where no matter what I say or do, it comes down to the abuse of this office. It did lead eventually to a RICO suit, a broad-reaching RICO suit against the entire state and actors all along the way. Naming, of course, amongst them Judge Malloy and Judge Lynch, who were the federal court justices overseeing this case. They dismissed themselves. They struck everybody from the case except Dave Edwards. Now keep in mind, remember what my previous videos, RICO requires a conspiracy between parties. It requires that there must be, without the rest of the defendants, the case collapses trying to bring a claim against one person. Even if it's repeated acts, there must be a conspiracy element. If only one defendant exists, how do you prove a conspiracy? They removed all the other co-conspirators. They removed all the other parties and made it impossible to proceed. I proceeded to a trial that I could not possibly win. And even then they handicapped me. They told me I had to present to the jury some financial loss. Well, there was no financial loss with Dave Edwards specifically because he didn't cause any actual loss except trying to prevent me from getting access to my business assets from Mara. So I tried to raise that to the jury. It was not even made aware to me I needed to raise that issue until trial. I'm sitting here trying to flounder and find some justification. Well, this case can't proceed unless you find he's done some financial damage to you. It's part of a larger scheme here. You removed all the other defendants. How am I supposed to prove that against one person? It's not a RICO claim anymore. The judge, who was a named party in the lawsuit, presided over the case to make sure I didn't mention his name. He then told the jury that they could actually use my prior conviction as a reason to deny the civil claim. He ignored, when there was a witness tampering issue that came up at the trial, he ignored it. He specifically gave instructions to everybody. You cannot communicate with your witnesses. You cannot talk to them. You cannot communicate with them at all until after this trial is over. I caught them, all of them, talking in the front room. Outside the courthouse, I brought it to the court's attention. I said, hey, Your Honor, they're talking. You said not to communicate with the witnesses. The attorney is talking with the witnesses out in the front room. And Judge Malloy sits on the bench and says, well, Mr. Glick, if they were out there talking about sporting events, I don't consider it an issue. If you were talking, for instance, what the latest Grizz game or Cats game is about. And of course, he comes back and says, oh, yes, Your Honor, that's exactly what we're talking about. We're talking about the sporting events this weekend. After telling me I can't talk to my witnesses, they're given free rein to talk and witness tamper and adjust their testimony accordingly based upon what's presented in the courtroom. Now, when I report it, it's ignored. Ultimately, obviously, the effort failed because I couldn't present a RICO claim. He sabotaged any ability to proceed with a RICO claim. He wouldn't appoint me counsel. He wouldn't appoint me assistance of counsel, regardless of my presentations and petitions for it. When I had one that was potentially lined up to potentially act as an attorney who was considering coming in, I asked for an extension to give him time to review the files and make a decision. Malloy wouldn't let it happen. He made sure I went in there unprepared. He made sure I went in there without being able to proceed with an actual case and sabotaged the case entirely. When you have the very corrupt officials within Montana defending Montana, once again, we're talking about the foxes being charged with overseeing the foxes. If you have foxes eating the chickens in the chicken coop, do you hire a fox to keep the other foxes from doing that? No. Makes no sense. But here we are. So, guess what? I managed to get through this without breaking down. Congratulations to me. Obviously, if you go back a few weeks ago when I tried doing a very similar story, I just couldn't do it emotionally. I managed to get through this. Yay to me. But the final reward here is that this is a personal story, and therefore, being a personal story, it's going to have a lot more detail and a lot more personal conviction, a lot less fact backed up, because it's going to be my own testimony, my own personal information. And by the way, ladies and gentlemen, my other cat is now trying to get over here, so if he comes over here and tries to get in here, please disregard. And in fact, here he comes. Hi, Wade. But at any rate, the whole point I'm trying to make here is that this is a procedural cluster of nonsense. And of course, you can imagine what word I want to have follow cluster. But as I've said, I've tried to keep these videos appropriately languaged, not using foul language or derogatory language. As much as I want to use cluster, which you can imagine the next word would be, it's a host of problems, ignored and upheld because the powers that be, who are the corrupt problem, are not put in a position where they're overseen or their conduct reviewed. When you go to the state Supreme Court, they uphold the state issues. When you go to the federal courts, they uphold the state issues because they're Montana actors. And when you go to the U.S. Supreme Court, the U.S. Supreme Court wants nothing to do with Montana or pro se litigants, so they just choose not to hear the case. If there's no oversight, no review, no expectation for them to uphold the law, why would they? I'm one voice in the dark. And, as I mentioned in a previous video, the best way to undermine any chance I have of speaking out is to convince the general public that I am guilty of a crime so heinous they don't have to listen to me. I've said repeatedly, if you want to hide a political prisoner, call them a sex offender because then nobody will listen to them. I become a conspiracy theorist, I become someone who can be dismissed. Forget the fact that every single one of the things that I raised is actual legitimate legal issues. Forget that I've published a book that has volumes of scanned and documented pages that prove my claims. Ignore all of that. You don't have to listen to it. You don't have to read it or even consider it because only look at the fact he is a sex offender. Not that I am, just that I'm convicted. That's all that matters as far as they're concerned because that's all they have to say. It's the only defense. Oh, that officer just shot a kid. Don't listen to him. He's a sex offender. That officer just cut off that guy's head. Don't listen to him. He's a sex offender. That's literally their only defense. They don't have to actually talk about the issues. They can lie about the issues. They're not required to uphold this. Interestingly enough, on the subject of the habeas corpus, I did manage to finally bring a habeas corpus before the Montana Supreme Court a year later. In that particular case, on April 20th, 2010, I did bring it. Supreme Court allowed my filing, asked for a response from the Department of Corrections, which primarily consisted of a affidavit from Dave Edwards, which presented a host of just completely misrepresented and lies and lies and lies. I requested the right to reply to it. Technically, there's two conditions here that should have allowed it. One, introduction of new testimony, new evidence, which does not have a chance to be refuted or rebutted. Therefore, a reply is appropriate. And second, I have a constitutional right to confrontation of my accusers. Dave Edwards was accusing me of hellaciously offensive behavior and conduct. I should have had the right to reply and to respond to his allegations and accusations. Supreme Court didn't want to hear it, and they adopted his side of the story 100%. They simply incorporated this is what Glick did because Dave Edwards says so. This is what Glick did, this is what Glick did, this is what Glick did. Therefore, we don't find any reasons or justifications to grant the habeas corpus. Now, keep in mind, they only addressed whether or not my conduct under probation rules or probation supervision was appropriate to grant. They didn't address the double jeopardy issue at all. They ignored it. They didn't address whether it was a proper sentencing issue, whether I'd been sentenced to probation or not. Ignored it. They didn't rule on the actual bread and butter, meat and potatoes of the actual constitutional argument of the writ of habeas corpus. They focused entirely on what Dave Edwards said I was doing and went with it and adopted it and said, well, Mr. Glick is just a problem case and therefore we're going to ignore him. And that was their decision. That was it. It's horrific. That's what it was. So, reaching the end of the video, as always, this is the part I don't like, but here it is. If you like my message, if you think what I'm doing is important, if you want to support this program, please look at the information inside my text attached to this video. It should have the contact for myself, Bill, to send any material or financial donations. Once again, if you are under supervisory supervision or in custody, please make a point of contacting Bill, not myself. I can't communicate with you. It's one of my conditions. But any information you wish to relay, of course, relay it to him. The ultimate goal here is that we want to set up a charity program that speaks out for anybody in these kind of situations. Towards that end, of course, we want to hear your stories. Submit them. Tell us about what's going on with you. Of course, I'll vet them. If I think they They deserve airtime if I think they're legitimate. I will absolutely bring them to the attention of the public, and I'll put them in these videos. But again, I'm not going to sit here and act as a defender for you if I think there's any doubt in my mind as to whether you're innocent or guilty. I'm not here to try to defend you in a court of law. I am here to present your story and the facts of your story to the public. So please make sure you provide any documentation, any records, anything that supports your position so I can better assess that. The last thing I want to do is come on here and defend you and find out, 6 months from now you confessed because you actually did it. I want to be able to defend the people who are falsely convicted, who are political prisoners like myself. Those are the stories I want. Any corruption issues, I want to hear them. So by all means, send me your information, send me your contact. If you wish to support us, please do so. As always, if for some reason you're watching this video and my information is not attached, you can go to monspiracy.podbean.com. That's where this podcast originates. Or preferably, go to YouTube. Look for the Great Montana Conspiracy Podcast. Like and subscribe. Like the video, subscribe to my channel. Support us. Mention us to 10 people, have those 10 people mention us to 10 people. Give me a chance to have my voice expanded beyond the small little circle of people that we've got so far. Let's get the voice out there, people, because I'm not speaking for just myself. I'm speaking for everybody. And I hope you'll join me in this and help support our cause and get our message out there. As always, whenever possible, please be safe. And once again, whenever possible, please be free. Thank you.